Hello friends, welcome to UPSC Logics, and today is a great day for the Indian justice system and the Muslim community, especially the women in India. So India has finally got rid of the triple talaq, at least has taken the first step towards eliminating triple talaq. So in this video we shall have some key points, timeline and judgment of this particular case, the triple talaq case. And it was a 5 judge bench which included Justice J.S. Keher, Justice Kurian Joseph, Justice Rohington Folly Nariman, Justice Uday Umesh Lalit, and Justice Abul Nazir. So as you can see, all of them belong to different communities and they have come given this landmark judgment. So let us have a look at what are the key points, timeline, and what were the main factors that were pointed out in the judgment. So before we begin with the case, let us have a look at what the government's stand on this particular issue was. To understand that, let us understand what triple talaq is. Triple talaq is basically a practice under which the husband can verbally divorce his wife by uttering the word talaq thrice. Now, Modi government had pitched against triple talaq and added fuel to this particular debate. A lot of people had called this particular stand by the Modi government as vote politics because they wanted the Muslim women votes, and but this wasn't the real intention of the Modi government, and it had made its stand clear on this issue and had informed the top court that triple talaq, nikah, halala, and polygamy violate Muslim women's right to equality and dignity and are not protected by the right to profess, practice, propagate religion under Article 25(1) of the Constitution. So what the Modi government had pointed out was the violation of fundamental rights of the women, and therefore it wanted this particular practice to end. So let us understand how this particular case came into picture. Now, Supreme Court had been getting more and more petitions from a lot of Muslim women in regards to this particular triple talaq thing, and they were asking whether it was constitutionally valid or not and wanted to know whether it was fundamental to Islam. So there was this particular person called Shaira Bano who was in the limelight, and she was given talaq in a letter with talaq talaq written on it. There were the cases where talaq was given on Skype and WhatsApp as well. So a 5 judge bench headed by Justice Chief Justice J.S. Kher was set up on May 11, and it began its hearing on all these petitions together. So this particular bench comprised of Chief Justice of India J.S. Kher, Justices Kurian Joseph, R.F. Nariman, U.U. Lalit, and Abul Nazir. And these 5 judges belong to different communities, so there was an equal distribution of all communities in this particular bench. And Bano, who was the main leader of this whole petition thing, said that it was time to end this particular atrocity against the Muslim society or the women of the Muslim society. And she's from Uttarakhand and had appealed the Supreme Court to declare the triple talaq as unconstitutional. She's also a postgraduate and belongs to Udham Singh Nagar and had to undergo 6 abortions because her husband had forced her to do so. So she was the main person who was in lead of this particular petition, now in great limelight. So let us have a look at the timeline of events. On October 16, 2015, Supreme Court bench asked Chief Justice of India to set up an appropriate bench to examine if Muslim women face gender discrimination in cases of divorces while dealing with a case of Hindu succession. So this was already in picture. February 5, 2016, Supreme Court asked Attorney General Mukul Rohatgi to assist it on the pleas challenging the constitutional validity of triple talaq, nikah halala, and polygamy. March 28, 2016, Supreme Court asked Center to file a copy of the report of a high-level panel on women and the law, an assessment of family laws with focus on laws relating to marriage, divorce, custody, inheritance, and succession. Supreme Court also impledes various organizations including the All India Muslim Personal Law Board as parties in the suo motu matter. On June 29, 2016, Supreme Court says triple talaq among the Muslims will be tested on touchstone of constitutional framework. October 7, 2016. For the first time in India's constitutional history, Centre opposes in Supreme Court these practices and favor a relook on grounds like gender equality and secularism. February 14, 2017, Supreme Court allows various interlocutory pleas to be tagged along with the main matter. February 16, 2017, Supreme Court says a five-judge constitutional bench would be set up to hear and decide the challenge on triple talaq, nikah halala and polygamy. March 27, 2017, All India Muslim Board tells Supreme Court that these pleas were not maintainable as the issues fall outside judiciary's realm. March 30, 2017, Supreme Court says these issues are very important and involve sentiments and say a constitutional bench would start hearing on 11th May. May 11, 2017, the constitutional bench begins day-to-day hearing. May 18, 2017, after 6 days of historic hearing on the bunch of petitions challenging the constitutional validity of the triple talaq, the Supreme Court concludes argument and reserved its verdict in the case. So this verdict has finally come in, and we shall just in a moment have a look at the verdict. So right now what I want to say over here is that this has been going on for a long time. In fact, from 2015 onwards this has been on, and this was only around May 11 that this particular Shaira Bano case and the other cases which involved the triple talaq came into picture. Before that, the Supreme Court was already working towards questioning the constitutional validity of triple talaq, nikah halala and polygamy. So the judgment has finally come, and let us have a look at the key points what this particular judgment involves. So after reading separate judgments, the five-judge bench of the Supreme Court ruled in 3:2 majority that triple talaq is void and illegal. Chief Justice of India J.S. Kher and Justice Nazir said triple talaq is a fundamental right, while three other judges, Justice Kurian Joseph, R.F. Nariman and U.U. Lalit, said it is not a fundamental right. So the bench was split on its decision in the favor of making it void and illegal. So 3 votes went to void and illegal, while 2 of the votes that belonged to Justice J.S. Kher and Justice Nazir said that triple talaq was a fundamental right. Justice Nariman, Justice Lalit and Justice Kurian said that triple talaq was unconstitutional. The Supreme Court has put a 6-month stay on practice of Muslim men giving their wives instant divorce through triple talaq. And the Supreme Court bench has asked the Parliament to make a new law on triple talaq issue in 6 months. If the law doesn't come into force in 6 months, the Supreme Court injunction on triple talaq will continue. The Supreme Court bench referred to abolition of triple talaq in Islamic countries and asked why can't independent India get rid of it. So this was a very valid question, and in fact, as we have seen from the key points of the judgment, that the Supreme Court has put its foot down on this particular issue, and although it was split and was a close match, but still this new ruling will make the triple talaq as void and illegal, and it is yet to be seen how the Parliament comes together and passes a law banning this particular practice that is derogatory to Muslim women. So this brings us to the end of this particular video on triple talaq and what the Supreme Court judgment has been. I hope guys you have enjoyed this video. In fact, I enjoyed a lot reading about it and about the case and about the verdict. And thank you so much for watching. If you're watching it for the first time, don't forget to press the subscribe button. And in case you're a regular subscriber and haven't yet pressed the bell icon, don't forget to press the bell icon for regular updates. So thank you so much for watching, and Jai Hind.